Okay, I'm sure we'll have more people logging in, but why don't we start the session now? Good afternoon, everybody. Welcome to the Canadian Centre of Excellence for Anti-Corruption, first of many webinars. My name is Pat Poitvin. I'm the co-founder of the CCAC, and I want to welcome everybody for this webinar session on remediation agreements, what you need to know about the new Made in Canada solution. We will be recording this webinar, make it available on the website. I would just like to ask everybody to make sure that they mute their microphone and their video at the bottom left of your screen so that we don't have too much noise while we're having discussion. And I will give the voicemail to Marc Tassé, my partner with the SIAC.
Bonjour à tous, j'espère que vous allez bien. Donc, juste pour mentionner que le webinaire va se dérouler en anglais, mais si vous avez des questions en français, il va nous faire un plaisir de les recevoir et de les transférer par la suite pour qu'on puisse vous répondre. Donc, merci beaucoup de vous joindre à nous et au plaisir d'avoir de vos nouvelles.
Thank you, Mark. So this webinar will be done in English, and I now cede the floor to Jonathan Drimmer, who will be moderator for this event.
Thank you, Pat, and thank you, everybody, for joining us today. I want to start with one or two ground rules, and then very gladly introduce our panelists and jump right into this webinar, which is focusing on remediation agreements, an issue that is both timely, lively, challenging, and incredibly interesting. The one caveat, obviously, as Pat mentioned, we are recording this. We aren't going to be talking about particular ongoing cases, and I know a number of folks might be interested in one specific ongoing case involving SNC Lavalin. We're not going to be speaking about particular ongoing cases today, given the sensitivity of those issues and the fact that we are lucky enough to have representatives from the government on our panel. Let me start. I'm Jonathan Drimmer. I'm a partner at Paul Hastings and the former Deputy General Counsel and Chief Compliance Officer at BARAC, and spent many years working with Pat and the CCEAC on its programming and processes. We have, we're lucky enough to have as one of our panelists, Stefan Hould, who is a Senior Counsel of Regulatory and Economic Prosecutions and Practice Management, the Economic Crimes Group, as part of the Public Prosecutions.
Oh, wait.
Hello.
Hello.
Hello. Am I back? Tom focuses on cross-border challenges and issues, and in particular, issues related to corruption and sanctions. And finally, we have Gina Campbell. Gina is she is a partner at Deloitte, and she's the Deloitte National Forensic Leader. She is also deeply experienced in providing advice and counseling regarding fraud and corruption, risk management programs, ethics compliance, anti-fraud controls, anti-corruption controls, deeply experienced in investigations, and she sits with me on the board of directors of Transparency International Canada. To just jump right in, I think it would be helpful to make sure we're all on the same page when we talk about remediation agreements, and we're going to be talking about DPAs as well. And Tom, could you just give us all a little bit of an explanation of what these terms mean? What's a remediation agreement? What's a DPA? How do they come up?
Sure, and I'll toot my own horn for a second here. It's Tom Best. I'm a partner of Jonathan's at Paul Hastings, Conveniently, Jonathan went silent when he talked about me, and I won't hold it against him.
Don't hold it against me. Tom is, as I was saying to myself, apparently, Tom is a very deeply experienced cross-border attorney, specialist in anti-corruption as well as sanctions issues, and he and I have practiced together for quite some time.
Right. So in a nutshell, a DPA in U.S. parlance, a deferred prosecution agreement, and in Canadian parlance, a remediation agreement, is an agreement between a prosecuting authority and a company or an individual. They can apply to individuals as well, in which the company or individual agrees with that prosecuting authority that it has engaged in certain conduct. It will take responsibility for that conduct, whatever it may be, i.e. violations of law. It may or may not formally admit to violations of law, but may admit to the facts associated with what might be alleged as a violation of law. And in return, the government entity, the prosecuting authority, will agree to defer prosecution subject to a number of conditions. And so what you have, and those conditions tend to be the company or individual takes responsibility. And probably most importantly, and certainly in the Canadian context, perhaps remediation agreement is a better term or a more descriptive term than a deferred prosecution agreement. One of those conditions is almost always that the entity or individual will substantially enhance its compliance program and its internal controls. In exchange for those promises and actions, the prosecuting authority typically will go to a judge. In the U.S., they have to, and obviously in the Canadian context, we'll hear about how the process works as well. That agreement is filed, reviewed by a judicial authority, and as long as the company or individual abides by its terms, ultimately that agreement will be dismissed and the company or individual will not be charged. If the company or individual fails to live up to the commitments it makes under the DPA or remediation agreement, then the prosecuting authority, of course, has significant leverage over that company or individual in order to seek additional assurances, potentially bring another enforcement action, or take other action as the authority may see fit.
Thanks for that, Tom. Jonathan, Stefan here. If I may just add one point of clarification to Tom's introduction to the description of this regime. Although true in the US for individuals, the remediation agreement regime in Canada is not available to individuals, only available to organizations. So I just wanted to make sure that I brought that distinction to the fore.
Thank you for that clarification.
Yeah, very helpful. No, appreciate that greatly. And I think if we could just talk for a minute, maybe each of you, starting perhaps with Vlad, about the different role that your entity will play in the remediation agreement process. We're lucky enough to have RCMP, we've got the Crown, we've got partnered at a major law firm, partner at a major forensic accounting firm. What role does each one of your entities play in the context of a remediation agreement and the process that goes into reaching one? And maybe Vlad, if you could start from the RCMP standpoint.
Absolutely. First of all, thank you for inviting me in this webinar. Thank you to CCEAC and all the panelists to do this webinar together. So just to give you a perspective on the RCMP point, I just hope that I'm going to be able to clarify our role in this process. And just to start off, our role in the RA or remediation agreement process is fairly limited, but somewhat, I would say at the same time, quite important, even though we're not really mentioned in the legislation, because our role as a law enforcement agency doesn't really change. We're the police, we investigate, this is our bread and butter, this is what we do. However, with the remediation agreement, there might be a conception or a misconception that we would not get involved, or we would not be conducting necessarily our thorough investigation. So for us, it's business as usual in the sense that we need to conduct a thorough investigation. Basically, it needs to meet the threshold of criminality. So it's not only simple allegations. We need to do our full investigation. And at the end of the day, why I say our role is limited, it's because basically what we're going to be asked is how the company cooperated with us in that sense. So the only thing, I guess, where it might change a bit, it's in the process of when we're conducting the investigation and the relationship and the collaboration with the companies. And all this is going to be on a case-by-case situation. We've had several companies coming forward, basically wanted to self-report. And generally what happens is that counsel will contact us, general counsel. They don't need to disclose the name of the company at this stage. But what they do generally and what they can do typically is really just sit down and discuss in what terms, I guess, or in what circumstances they want to cooperate and how they're going to be doing it. So on the other hand, what we've noticed since the legislation has been out is that the companies that are currently under investigation, regardless CFPOA or criminal code, there's a shift in the mindset. And so because the legislation now is out, we've had several requests of those companies basically requesting to benefit from the remediation agreement process. So like I said, we're not the decision makers. For us, we're the initial step. We're kind of the doorstep, and that cooperation, we're going to be asked to comment on it. And I like to use that phrase, and I think, Stefan, you've heard me probably quite enough saying it, where I say that legislation is not made it's made actually to encourage the companies to come forward and not to entrap them. And we here at the RCMP, and specifically our unit, because we deal with sensitive matters and we deal with high-profile cases, we're ready to work, and we want to work with the industry and want to work with the companies and make this happen. And we'll do our part, as long, obviously, as the company does their part. So,
but then maybe if I could just stop you at the point. Maybe Stefan, maybe you should come in. Vlad started talking about your relationship and your conversations about the remediation agreement process. Maybe we should bring you in and talk a little bit about how the Crown sees these things and works with the RCMP on them.
So thanks, Jonathan, and thanks, Vlad. If I can pick up where Vlad left off, unlike the U.S. model where prosecutors are involved in the investigation and the prosecution as wearing both hats, in Canada, obviously, we have distinct roles. So the investigation belongs to the law enforcement agency. Prosecutors don't have decision-making authority in that regard. Where do we come into play with regards to remediation agreements? Vlad talked about cooperation. That's a key component that I'll be talking to a little bit later. But if I can summarize the role of the Crown in this process, I think I can break it down into 4 steps, decision-making steps that are important in the process. The first is the assessment of conditions, whether or not to invite a corporation to a remediation agreement. I must point out that decision rests solely or ultimately with the Attorney General. In the case of the Federal Prosecution Service, the Public Prosecution Service, the federal authority, it rests with the Deputy Attorney General, who is my big boss, the Director of Public Prosecutions. So where does the Crown come into play? Typically after the investigation that Vlad mentioned is completed, because the conditions, the preconditions for a remediation agreement to ensue is the assessment of whether or not there's a reasonable prospect of conviction. And I mentioned in opening that remediation agreements are only available to corporations. Of course, in Canadian law, that calls into question, the role of senior officers and so on. The second aspect or precondition that is key is whether or not the remediation agreement is in the public interest. And maybe to pick up on where Tom left off, typically a remediation agreement is a decision that's going to be made whether or not to pursue with the charges or whether to offer a remediation agreement, and that will ultimately stay the charge, but it contemplates the laying of charges and paying later on. So that decision is a prosecutorial decision that's made by the Crown, by the prosecutors. And there's an initial assessment that needs to be made. Once the Director of Public Prosecutions has given the green light to go ahead and negotiate one, then the prosecutor will send an invitation to negotiate.
There's a lot of feedback. I don't know if I'm the only one, but it's actually a little bit hard to understand what you're saying, Steph. It seems that it's increasing.
Okay. How is it now?
Same. I don't know. Is it only me, or is it? If it's fine for everyone,
yeah,
I'll say anything.
There's a fair amount of feedback coming in. Maybe what we should do is come back to Stefan and yeah, why don't we bring in some of our two private sector experts, and we haven't heard from you yet, Gina. Why don't we chat a little bit about how Deloitte and your group gets involved when we talk about DPAs and remediation agreements and that process. What role does the forensic accounting firm play as part of this?
Great, thanks, Jonathan. So we're typically involved we're involved in items leading up to and are happening before a remediation agreement. So we're typically retained by legal counsel on behalf of their client, which would be an organization or company. And forensic professionals are involved in investigating concerns or allegations to understand the facts of the matter. The forensic team, the investigators, bring a varied skill set. So in addition to accounting, the investigation and the forensic investigators typically will do financial analysis, interviews, intelligence research, electronic document collection and review, and transactional analytics. Our role firstly is to obtain facts surrounding the allegations, and to the extent that there is an issue identified, potential wrongdoing or issues of concern, and then ultimately interactions with applicable authorities, we may also be involved in describing the investigative process that was undertaken, what the results of that was, the findings, speaking to key documents or analysis. And we can also be involved in assessing or commenting on the anti-corruption compliant programs and controls that were in place at the time of the incident, or that may have been implemented post-event. It's essentially, in order that according to the remediation agreement legislation, there are a couple key items that the prosecutor must consider, and a few of those build directly off of the investigative work that our firm would be involved in, such as the circumstances in which the act or omission, what happened, the nature and gravity of the act or omission, and the degree of involvement of senior officers of the organization in the act or omission. So those are kind of the key sections of the legislation where the work we've done would feed into the remediation process.
Great. And then Tom, I know that you and I have from the U.S. side certainly seen lots of discussions with the Department of Justice around remediation agreements, DPAs, and other forms of consensual resolutions. And it's obviously a fairly deep history in the U.S. Why don't you talk a little bit about the law firm role and how the law firm, what the law firms really do in terms of managing the process from their end, as far as consensual resolution, DPAs, remediation agreements.
Right, and I appreciate that, and obviously jump in when you have comments as well. And I'll speak first from a U.S. context, but it will hopefully frame sort of where Canada is and maybe where Canada is going with the remediation agreement regime. As a law firm, external law firm, we are typically engaged by an organization, by a company, to first, in large investigations that ultimately come before the Department of Justice or maybe the U.S. Securities and Exchange Commission, maybe the RCMP or other investigative and enforcement authorities around the world, most often start not as big investigations, but as small queries that may need to be looked into. So oftentimes the legal department or general counsel of a company or chief compliance officer will call us up and say, hey, we have this situation, what do you think? And depending on the facts and the context, we might recommend a course of action. Maybe that's limited internal investigation, maybe that's some due diligence, whatever it may be. We provide some advice, but ultimately we'd end up in a situation where we, on behalf of the company, would be investigating facts and circumstances of whatever issue had come up and helping the company then make a determination as to the best way in its interest to protect itself from ultimate enforcement action. Now, sometimes what ends up happening is the risk of detection or disclosure of whatever issues come to light becomes sufficient that it may be in the company's interest to go affirmatively to, say, the U.S. Department of Justice or SEC or both and make a quote-unquote voluntary disclosure. It may be that the U.S. or other securities laws dictate the fact that as a matter of a company's disclosure obligations, the fact that there's an investigation in a country about an issue may need to be disclosed as well. But however the issue becomes before the regulators or the enforcement officials, once that happens, we have a couple of different roles. One will be investigating the facts and circumstances as deeply as we need to in order to advise the company on how to respond to media inquiries, how to effectively remediate the conduct. But first and foremost, we'll be trying to steer that company, advise it as to how best to engage with regulators, if we've gotten there, to mitigate or hopefully eliminate its enforcement risk. Now, in the U.S., there has been, especially over the last 3-4 years, the U.S. Department of Justice and the SEC has kind of drafted on them to some degree in practice, has constructed really by policy pronouncement in the forms of different kinds of memoranda issued by senior Department of Justice criminal division officials, constructed an incentive system which over the last 4 years has gotten to a position where if you are a U.S. company or a company that has U.S. legal exposure, even if you're foreign or non-U.S., and you affirmatively, voluntarily disclose potential wrongdoing to the DOJ, you then turn over all information about potentially culpable individuals and cooperate, remediate, and enhance your compliance controls, et cetera. The DOJ has said that there will be, if you do all those things, a presumption of a declination of enforcement as long as the company then would disgorge or turn over any kind of ill-gotten gains or profits it might hold. That's a pretty significant departure from where we were, say, 10 years ago. If you don't fulfill all those conditions, there are then various gradations of ways that matters may resolve themselves vis-a-vis the company and the regulatory or enforcement authorities, short of a criminal prosecution, a criminal plea, or a conviction. And that would be a declination, as we talked about, maybe a non-prosecution agreement, which wouldn't go before a judge, maybe a DPA, as we've talked about, which is sort of most like a Canadian remediation agreement, and some other forms as well. And so companies, our role as law firms, is to help companies kind of get the best deal they can while navigating this sort of complex incentive system, and also making sure that they can run their businesses at the same time. Let me stop there and see, Jonathan, if you want to add anything else.
Yeah,
stop there. No, I mean, I do think we have a question that's come in through the group chat that I'm going to throw out there to all four of you, and particularly, I think, interested to hear from our government colleagues. But it relates to that, Tom. So, Tom, you were talking a bit about the end of the process, full disclosure, disclosure of facts, disclosure of individuals and their roles and what they might have played in connection with the underlying events, which can create internal tensions, no doubt. The question that's come in through the group chat, and would encourage anybody who is participating to shoot us questions through the chat. And the question is, are there interim conditions that are applied to companies that are seeking a determination during the process that leads up to the consensual resolution? So you talked about the end of the process, Tom, but what conditions are there, and maybe we'll start with the government, that companies should be thinking about during the investigation process, during the engagement process with the RCMP and the Public Prosecution Service, that can best position them to enter into a favorable consensual resolution?
If I may take the lead here, Jonathan, to answer that question. It's a very, very relevant question. I will let Vlad kind of chime in into the investigative stage. Let me pause for a second to say that in that assessment that I mentioned about earlier, whether or not to move forward with the remediation agreement, there are several components that form several factors that the prosecutor must examine in his or her assessment of the public interest. I won't run through the whole list, but to highlight just a few, the circumstances that Gina spoke of as to how the conduct has been brought to the attention of the law enforcement agency, of the authorities. Is there any restitution that's been made by the corporation? Are there any efforts that have been made to identify the victims? Not only identify those responsible for the conduct when we're speaking about internal employees and directors and officers, but has there been an effort to identify where the victims are and what type of restitution has already been commenced? Because ultimately that will be a mandatory condition of the remediation agreement. So that's part of the assessment. I think at the end of the day, the assessment of the compliance program and you know, although it's not a prerequisite, you know, self-disclosure and the presence of a compliance program is not a prerequisite. It's certainly something that would come into play in that assessment. And so I think it's in the benefit of the corporation who wants to come forward and solicit a remediation agreement. I think it goes without saying that type of voluntary disclosure and cooperation with the authorities is essential, although not a prerequisite. I think it's essential if you want to put the best case forward in order for that assessment to be made favorably. Of course, this brings into play, when does this happen? When can you be giving those assurances? And because the ultimate decision rests with the Attorney General before we give the green light to go ahead, of course, there's always the danger of fettering that discretion. So you won't get prosecutors to tell you, well, you know what, if you supply me this, I can guarantee you're going to get a remediation agreement. You have to have a leap of faith going in to say, well, it makes good corporate citizen sense to go ahead and put all of our chances on our side in order to get those. And again, I'm not a defense attorney. I'm not going to speak on behalf of the defense bar and how you counsel your clients in this regard. But from a prosecution perspective, there certainly is a benefit in doing so rather than wait much later in the process where your chances might be diminishing. I don't know if I've answered the question, but as regards the conditions midway, I'm going to leave that to Vlad, because during the investigative stage, you know, the prosecution is not going to take positions in that regard. That belongs to law enforcement authorities.
Yeah, well, let's hear what Vlad says, and then maybe we'll comment a little bit with some of the U.S. experience on this. But Vlad, what's your take on this? Interim measures for companies that can best put themselves in a position at the end of the process to enter into some type of a consensual resolution.
Yeah, it's a good question. It's a kind of a good point. I think in all, it comes down to how the cooperation obviously is going to go. And probably it's a point I forgot to mention a little bit earlier. It's how the interpretation of cooperation may be. So, and I'm going to explain myself. What the company may consider cooperation might not necessarily be the same for law enforcement. And this is why we need to establish some ground rules, and we try to establish protocols with companies when they do come forward and have that discussion, that dialogue. And I'm not saying it's easy, and I'm not saying negotiations are going to be easy, but if the company is already coming forward, has the determination to make amends and basically come forward and basically simply, yeah, like make amends of the facts and want to come clean to that effect, well, we're ready to work with them. So kind of mentioned, so the protocol, we try to basically encourage to sign some sort of pre-agreement and establish those ground rules and make sure that we're all on the same page and we understand each other. Like I said, it's really going to be that dialogue. It's not, I'm not part of the process, obviously, but I talk and I speak with the investigators, but because my role is more on the prevention aspect, but I do ask some questions and speak with them. And this is where specifically our unit, we're trying to go, and we're trying to help the companies, if I can use that term, to basically go through that process. And it's obviously a case-by-case situation. So I can't speak of any specific situation, but everything is going to be definitely a case-by-case.
Sure. Yeah, look, in the U.S., I'm very interested, glad to hear from Tom and Gina a little bit on what they've seen in other jurisdictions, because what I heard from you is cooperation is really going to be significant, yep. which is certainly true in the U.S. Well, cooperation is critical. But what I heard from Stefan is, making things right, remediation, and the different ways that we get to remediation through compliance programs, through potentially trying to maybe even restitution if there are individual victims involved. Is that something you consider as well on the RCMP side? What steps are being taken from a compliance program, remediation efforts? Is that something that the RCMP takes into account?
Well, for us, for the compliance program, we're not specialized in this, so we're not gonna go in territories where it's not our expertise. We're gonna follow the numbers. Obviously, we have forensic accountants that are going to be helping us, assisting us in our investigation in order to build our case. But when we talk about specifically compliance, this, obviously, we would look at it, but again, we would need to see if it's been applied. So, and I know we've heard several cases where companies may have, or I heard stories where companies will pay, or they're going to ask, solicit a firm to have a compliance program, and it's going to be off the shelf, but it's not necessarily applied within their policies necessarily. It's just to say that they have one. For us, obviously, I think there's some things that are going to be easily and can transpire through emails and through the information that we gather. Another point I wanted to mention, just to follow up, is that when actually a company does come forward in the process of collaboration, there's things that can be easily done. And for us, it's also a way of us changing the way that we do business. And just to give an example, let's say a company comes forward, instead of hitting the company with a search warrant without them knowing it, we can have that discussion, because we know there's sometimes expectation of privacy for electronic devices. So we can sit down and say, okay, you know what, we're going to be issuing a search warrant or production order. The company can prepare the documents in advance. So instead of having us come over with 15 vehicles and for the company and dealing with the situation, it can be like just 2 officers coming over, meeting in an office and getting the evidence and getting it. because there's also the balance where we can't just simply rely on what the company tells us. Obviously, the company needs to be forthright and provide everything. That doesn't mean that the company needs to relinquish privilege, but at the same time, the company needs to show that they're open and they're willing to provide the information and not stalling, for instance.
Well, let me ask you this question, and Tom, maybe you and Gina can comment on both what we've been chatting about, interim steps. But one interim step that I want to throw into this discussion for everybody maybe to chime in on is, you know, when the government should be notified versus when key witnesses are going to be interviewed. And again, as we think about cooperation and as we think about what running an investigation and disclosing and interim measures, how would interviewing key witnesses before notifying the government sit with everybody? What are the factors that go into those considerations so that you don't have the government come back and say, hey, wait a second, you tainted this witness, or you tipped this witness off and we wanted to interview them first? So maybe we'll start first with the private practitioners and come back to Vlad and Stefan on that.
Sure, it's Tom. I can jump in here, and I guess I'll answer the question from a few minutes ago because it, along with this, because it all fits together. So, are there any ongoing sort of interim conditions? And the answer to that is sort of formally no, but in practice, yes. And the touchstone as a private practitioner, when we're advising companies, helping them execute investigations and deal with governments or the government, is how do we, once we've decided that we have to engage with them, how do we bolster that cooperation record as best we can if we believe that it's in the, and the company's decided it's in its interest to cooperate. And so that's, in the US, there's now a fairly developed set of guidelines and policy pronouncements on what cooperation is. And certainly it's production of all relevant documents, it's production of witnesses for interviews. There is guidance also out there, Jonathan, to your immediate question about quote unquote deconfliction. And here's where I think our job is as much art as it is science. If we've got a key witness, we're at the very beginning of an investigation. Maybe the government has said, hey, come in and talk to us a month from now after you've done some preliminary scoping. And yet I know I've got a key witness that needs to be interviewed with documents. You know, that scenario feels to me, all things being equal, that we wouldn't need to tell them that we're going to go do it in advance. But I can envision a scenario not tweaking too many factors where if the government had told us, look, we are doing a whole bunch of different independent investigation and we have specific interest in a set of certain key witnesses, and yet they didn't want to tell us who they were, we might decide to give them a heads up first, or find some sort of elegant way of letting them know that we were going to take the first shot at them and give them an opportunity to object. And so it's a very much a facts and circumstances set of determination, but that judgment can be quite critical especially when you're dealing with different jurisdictions, say the UK, and you might have different expectations from different regulators or different enforcement officials as to what tainted witness testimony or evidence might look like. The US tends to be a little more permissive in this way, whereas some other jurisdictions, if you as a private lawyers have done an investigation on behalf of the company and interviewed a witness, that evidence might not be admissible in court in circumstances in other interested jurisdictions. Let me stop there and see who else wants.
Yeah, goes to cooperation. So Gina, let's bring you in.
Yeah, so
give us your take on this stuff.
To build on what Tom talked about, I mean, I fully agree with this kind of art versus science, and you also have the practical challenge of what have you been doing before you got to the point of deciding you want to speak to the authorities around a potential remediation agreement. You may need to talk to some of these people as part of your internal investigation in order to understand whether you even have an issue here or not. And so some of these people may have already been spoken to in order to get to a determination on whether you have an issue, a potential issue, or something you even speak to the authorities about.
Sure. You got to understand whether you have an issue at all.
If I may chime in, Stefan here, if I may chime in, Jonathan, maybe just to add to Tom's comment about different jurisdictions having different legal frameworks, without providing and opening that Pandora's box here in Canada as to the issue of internal investigations versus what's disclosable later on once charges are laid against individuals or other corporations. Obviously, that's something that investigators and prosecutors will turn their mind to during the process. And so it's something that's delicate. And I think you aptly pointed out what the issues might be that you want to keep your investigators in check. And I don't want to speak on behalf of Vlad, but at the end of the day, full cooperation doesn't mean just investigating on your own, but also being alive to the issue of what law enforcement is doing. And of course, that's a delicate exercise to be made. And I'll leave it at that, and maybe let Vlad speak to the RCMP's perspective.
Yeah, and I guess it's, I think I am going to try to keep it simple in the sense that for us, in any type of investigation, it doesn't have to be necessarily financial crime investigation related to remediation agreements. We'll always have situations where we have witness tampering or those kind of situations. So obviously for us, if there's a key witness that's really important in the investigation, again, I guess it's just to sit down and advise the investigators, because when a company is forthright and basically lays out that information right away, I guess it always kind of, it's beneficial. Maybe the company may have some legitimate reasons of not providing that information. It is possible, like every situation is different. But again, if the company can do so, obviously I would suggest to do so. And in another case also, if the witness or the information that the witness has is really crucial, for obvious reasons, we're probably going to be re-interviewing, even though there's an internal investigation that was done. We would have to do our own interview with that witness, just to ensure that it also meets a certain threshold in regards of making sure that there's no inducement and there's no threat, and so there's all the police cautions, and we'll take the statements appropriately according to the situation and bring it to the courts. So bring it to the Crowns.
Yeah, this is incredibly helpful. So let me take us to a slightly different place in the remediation agreement discussion. And we talked a bit about different jurisdictions, different challenges, different laws. And in my mind right now, for this question, I'm particularly thinking about host jurisdictions, developing countries and other host jurisdictions where the underlying activities might have occurred, that we have a resolution in North America. One of the concerns that I've heard and I've seen and talked with folks about is that a company can enter into a remediation agreement, it can fully disclose. Doesn't that create risks, or does that create risks that then host governments are going to end up targeting local employees in a manner that we don't always think of as fair, that they will seize upon the remediation agreement through their own investigations in a way that we're not completely comfortable with from a fairness standpoint? And maybe I'll start with our private practitioners first, Tom and Gina, and get your reaction to that.
The short answer to that question is yes, it does create a risk. And one of the things that we do when we assist companies with is when we know and we're involved in a settlement coming that's going to be released publicly, we've done this a number of times, we help prepare if there is a risk, especially in some more difficult jurisdictions, help them prepare their local management with either contingency plans or just advise that management and certain key people to go on holiday for a little bit. But yes, it's I've had a number of personal experiences with exactly that scenario.
Yeah, Gina, you want to come in?
Yeah, for me, there's obviously risks and concerns because the decision on whether to make some kind of self-report or to even enter into the process that would lead down to an ultimate remediation agreement or deferred prosecution agreement in the US is a very, very difficult decision for organizations, their management teams, and board of directors. Because the potential risk, the exposure, the multi-jurisdictional considerations are very complex and complicated. And they do, even for organizations that want to do the right thing and put this behind them and move forward, and they would fit the absolute criteria for being qualified for a remediation agreement. It's a very, very difficult decision because of the potential risks that need to be weighed.
Yeah. So Stefan, Vlad, what do you guys think about this risk, and how do you guys think about it in the course of an investigation?
Can you go, Stefan? Actually, I was going to ask you, could you just, and I missed part of the question a little when you mentioned it, can you just reframe it for me, please, if you don't mind?
Yeah, of course. So one of the issues that we've seen as we talk about with remediation agreements and full cooperation and full disclosure, one of the concerns and risks is that, in the home jurisdiction, whether it's Canada or the US and North America, individuals who may be involved in the underlying actions, they'll get due process. And there is a process that we actually think is fair in assessing their involvement. But in some of the host jurisdictions, they may not have that full set of processes. And the concern is that host jurisdictions might use the remediation agreement and disclosure process against local employees in a way that concerns us.
Perfect. Yes. Okay. So that's why I just wanted to make sure. So for us, and if you don't mind, Steph, I'm just going to jump in real quickly. So we have liaison officers, so police officers, Canadian RCMP police officers who are deployed all around the world. So we cover off pretty much the whole planet. Now, obviously, there's countries where we do have good cooperation and there's no problem making certain requests, and they do follow the due process, and we do get this information, and generally we'll go through MLATs, which if people are not familiar with it, there are mutual legal assistance treaties where we make the request to gather that evidence overseas and get it back here so we can use it in our investigation. However, certain countries clearly have some human rights issues and may cause maybe harm to certain people if we're asking certain questions. And we have to be very careful and very cognizant. And there's cases and situations where I've learned that in the past we haven't made requests specifically knowing that those people or individuals could be harmed. So we have to get the information in other ways and by other means, obviously. So if in a nutshell, this is how I would, basically this is how it actually works on our part.
If I can chime in.
Stefan, what about you?
Yeah, so the question I think is relevant from the prosecutor's standpoint, maybe a little bit later on in the process, but assuming that the investigation is complete and the matter is remitted to a prosecutor to make that assessment that I spoke to earlier, whether there's reasonable prospect of conviction and whether it's in the public interest to move ahead with a remediation agreement. Although it's not reflected in the body of legislation that appears in Part 22.1 of the Criminal Code, there is one basket clause there when it speaks to whatever other factor the prosecutor deems relevant in the circumstances. And that's a perfect example of such a circumstance where the prosecutor will definitely turn their mind by speaking with law enforcement agency as to whether or not this remediation agreement, because it will have to involve full cooperation and who it involves, whether it's in the public interest or not to move ahead with one. I mean, the same question would be alive whether or not you're moving with a traditional prosecution. I don't think that changes. I think that's the type of public interest considerations that that prosecutors are alive to constantly, and certainly at the time of assessment whether or not to move ahead with this type of resolution.
It's great, important issue. So we've got about 7 minutes left. Please do send in any last questions you might have. But let me ask, and I want to start with our private practitioners, maybe Gina on this one. It's a two-part question, and it's almost to sum up. So number one is, why is it good for companies to want to enter into consensual resolutions? Why is this something that companies ought to really be striving for? And then how do we make consensual resolutions, remediation agreements, a reality in Canada and attractive when looking to resolve criminal investigations? So maybe Gina, we can start with you, and then Tom, and then move over to our government participants.
Sure. I think the organizations that I've spoken to about this and in the situations I've observed, the remediation agreement process is attractive for a couple reasons. One is it provides insight into the process, and our RCMP colleague made a comment about this. You're able to be involved in the process, participate, so you're not getting surprised with search warrants. You're being proactive. You're able to respond. You're able to manage it. So there is a benefit to having that open dialogue about what's happening and what information is relevant. It also, most organizations, if they do find they have an issue or a potential issue, do want to resolve the matter, fix whatever might have not worked, close loopholes within their processes, and move forward. And a remediation agreement will allow them to get some certainty around it. I think the challenge for companies in Canada who would be dealing with the Canadian authorities is that, and I'll let Tom speak to what he's observed in the US, but until we have some of these, you have to trust a bit that this process is going to happen, how it will work. And so I think once we get once there's a track record of having these agreements, I think there'll be a lot more organizations that are willing to take that leap of faith that I think another panelist had mentioned, and move forward because they're looking for certainty and resolution, want to do the right thing. If they've done something wrong, and deal with that and put it behind them and move forward.
Right, thanks, Gina. So I view negotiated consensual resolutions as ultimately in the public's interest, in the government's interest, and in the corporate's interest, for the following reasons. Now, and you do see out in the literature and the sort of wider community some criticism that you don't have companies are held to account in a public trial in various jurisdictions around the world. But as this practice of negotiated resolutions in the US has really developed really since the early 1990s up till now, and now we have hundreds of them on the books, what we now have is a fairly robust culture of companies. Gina, as you mentioned, most companies want to do the right thing. Not all, but most. They want to get their systems in place. They want to remediate whatever conduct they can, and they want to cooperate with the government, with a governmental authority, who itself certainly has an interest in holding a company to account for violations of law, but also doesn't want to unnecessarily penalize shareholders and others in the companies or other employees that had nothing to do with the bad conduct, and also don't want to divert resources away from going after other kinds of crime or other kinds of issues that, say, might be more pressing for the public good. And so, what we've got in the U.S. now is a system where there are incentives that the DOJ and SEC have put together that, in the right circumstances, it can make sense for companies to do things like voluntarily disclose, cooperate, etc., which then give them some certainty that they're at least not going to be in a criminal plea or a criminal conviction resolution, but also then give the government some certainty that they're going to be able to hold the company to account and ultimately get to what the public policy really ought to be in this case, which is we want to make sure that companies have better compliance programs across the board so wrongdoing doesn't happen in the first place.
So, Tom, you sound like you're a government representative. You've just stole my thunder because these are all the points that I had written down. But reflecting back on the Canadian model, if you look at the objectives that are announced at the beginning of Part 2 of the Criminal Code, those are the exact points that are some of the exact points that are behind the logic of moving forward with these. And I like to think that good corporate citizenry also means that, as you mentioned, Tom, innocent employees and innocent third parties of this conduct, that's what this route provides. And one would like to think that, compliance and remediating is something that you would be proud of if your employer were to move forward with that and say, I'm fully cooperating, I'm fully remediating. I think it makes a lot of business sense in all senses of the word, both accounting to society and accounting to your own good business sense. And at the end of the day, from a prosecutor's standpoint, I think that's what the guiding light is behind all of this, is whether it makes sense, whether it's appropriate to enter one of these as opposed to going to the formal route of a trial. And I will just end it by saying that not going to trial doesn't mean that the facts are not going to come to light, because as we know, these agreements will go to a court for approval and they will have to be public. All of the facts that gave rise to the conduct will have to be made public. So from a public standpoint, it's not like this is a backdoor kind of deal, and it's all in the open, and there is judicial approval and supervision. And I think at the end of the day, if investigators and prosecutors can contribute to that through this medium, I think it makes sense where it's appropriate.
Vlad, any final thought on this?
Yeah, actually, obviously, all the things that were mentioned just a little bit earlier are pretty good. And also, I guess, even though our part, like I said at the beginning, is limited, but at the same time, I do believe that it sets the tone for the rest. So and what I talk about the tone is the collaboration and sitting down with us. That exchange will start and set the tone for the remainder. Obviously, we're going to report and inform Crown of how it went, but at the same time, because certain ground rules are put in place, it's all to the advantage for the company to do it, and for us too, because at the end of the day, when we do have a company that provides information much quicker and there's a lot of delays that are actually reduced, it helps the company to move quicker to the next step. So once we're out the door, if I can use that term, they go off and deal with Crown afterwards. So that's the way I see it.
Well, with that, I think we're going to thank our panelists, real true experts in the field, for joining us and giving us their insights on remediation agreements. Before I turn it back over to Pat and to Mark, I want to issue a big plug for the CCEAC. Encourage everybody to visit the website. It's got a lot of great information and materials, a lot of great instructions, a lot of good samples. Check for some of their programs, which are just terrific and leading edge. So encourage everybody to go to the website and see what the CCEAC is up to. And with that, Pat, Mark, over to you.
Thank you very much, John, for moderating all this. I want to thank all the participants and obviously the speakers. I think this was quite informative, instructive as well. This is a new process in Canada. So, I mean, we don't have the precedents yet. So this is just the first step for us learning about this process, and I'm sure we're going to be talking about it some more. And you can be assured that the SEAC will be there to bring more discussion around this topic, and we'll invite the same people and others to participate and move forward. And we also invite all the participants to suggest other topics that they'd like to see surrounding anti-corruption, compliance, and ethics and governance that we can turn into webinars with the SEAC. So with that, I would like you to emphasize that we will put this recording, the recording of this webinar, online for everybody to access. And if you do have some questions later on, please submit it to us, and we'll be able to gather those questions, send them out to the speakers and others, and then post it on SEAC to enhance our knowledge about these issues. Thank you again, and we'll see you soon.